Hi students. I hope you have understood part 1, right? So let us just have a quick recap on what we have discussed in part 1. So we have discussed chapter 1 in civics, that is in Indian Constitution. So in that we have discussed about what are the learning objectives of the lesson, next introduction, the need for a constitution, making of Indian Constitution, then salient features of Indian Constitution, next preamble, and Citizenship Act of 1955, acquisition of citizenship, then fundamental rights we have noted, discussed, right? Yes, fundamental rights also finished. Yeah, then suspension of fundamental rights we have discussed, and directive principles of state policy, and the difference between fundamental rights and directive principles of state policy. These are the things which we had discussed in the last session, that is part 1. Now today in part 2 we are going to discuss about, like we have discussed, like suspension of fundamental rights, the difference between fundamental rights and directive principles, right? So in page number 242 they have given a colorful picture. So that is, number 1 is right to equality. Right to equality, these are articles. So children, these are from the Indian Constitution. We have a written draft one, right? Written draft constitution. In that, first one is about right to equality. So they are in article 14, 15, 16, 17, 18. So about right to equality, article 14 is equality before law. So before law there should be equal judgment for all the people. And article 15, prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. And in article 16, equality of opportunity in matters of public employment. Article 17, abolition of untouchability. You know, right, what is untouchability? Those days there is a caste problem between the higher caste and the lower class, and the lower caste people should not touch anyone. This untouchability formality will be followed. So abolition of that. And in article 18, abolition of titles except military and academic are introduced. Okay. Now second one is about right to freedom. Right to freedom. So when we ask about right to equality, you have to write all these points, children. Or if we are asking right to freedom, you have to write like these points given. It is really very clear in the textbook mentioned according to the articles and also point wise. So right to freedom is second one. Article 19, freedom of speech and expression, assembly, association, movement, residence and profession. So according to article 19 in second right to freedom, people have freedom to speak what they think, what they are willing to speak, and they have the freedom to express what they want to talk. And assembly, association, movements, residence and profession, they have freedom for everything. According to article 20, protection in respect of conviction for offences, and 21 is protection of life and personal liberty, protection of life and personal liberty. Article 21A, right to elementary education, and article 22 is about protection against arrest and detention in certain cases. Next, right against exploitation. Right against exploitation. Article 23 and 24, prohibition of traffic in human beings and forced labor. So we have to stop the forced labor in the human beings. Okay, that's been prohibited. And article 24, prohibition of employment of children in factories. So Child labor is also prohibited according to Article 24 again in the rights against exploitation. Fourth one is right to religion. Article 25, 26, 27 and 28. Freedom of conscience and free profession, practice and propagation of religion. Next, freedom to manage religious affairs, freedom from payment of taxes for promotion of any religion, freedom from attending religious instructions or worship in certain educational institutions. Next, fifth one, cultural and educational rights. Article 29, protection of language, script and culture of minorities. Article 30, right of minority to establish and administer educational institutions. 6. Right to constitutional remedies. Article 32, it allows individuals to seek redressal for the violation of their fundamental rights. Now coming to the fundamental duties. This is in page number 243, children. Fundamental duties. The fundamental duties in the Indian Constitution are inspired by the Constitution of former USSR. So these basic duties in the Indian Constitution, the Indian rules, statement laws are inspired from where means from the constitutions of former USSR. So in 1976, the Congress party set up the Sardar Swaran Singh Committee. Sardar Swaran Singh Committee to make recommendations on fundamental duties. So in 1976, the Congress party, it has started one committee that is called Sardar Swaran Singh Committee. Underline this point, children. This committee is only to suggest, give some recommendations on some basic duties, okay, in the India. The 42nd Amendment Act of 1976 added some responsibilities of citizens to our constitution called the fundamental duties. So this is what in 42nd Amendment Act of 1976, they also added some extra responsibilities of citizens to our constitution, which is called the fundamental duties. This amendment added a new part, namely part IVA to the constitution. This new part consists of only one article, that is article 51A. As we have seen all these parts, this is part 4A, children. In all these parts we have seen so many articles are there, but here in part 4A of the constitution, it has only one article, and that is article 51A, which for the first time specified a code of 10 fundamental duties of the citizens. So in that article 51A, there are nearly 10 codes of fundamental duties. So let us see what are all those points. Okay. The first one, the list of fundamental duties. So they said there are 10, right? First one is, wait children. First one is, like article 51A declares it to be the duty of every citizen of India. So this 51, this is article 51A, it declares to be the duty or responsibilities of every citizen of India. First one is to abide it to be duty, sorry, it to abide by the constitution and respects its ideals and institutions, the national flag and the national anthem. Okay, first we have to give respect. It is mandatory for the citizens of India to give respect to the national flag and the national anthem. To cherish, second one, to cherish and follow the noble ideas which inspire the national struggle of freedom. So we have to admire and we have to follow the ideas, the great ideas which was given by our national leaders, national struggle from freedom, which we get from that. Third one, to uphold and protect the sovereignty, unity and integrity of integrity of India. So We have to protect the sovereignty. Sovereignty means what? Means we have to uphold, we have to say, we have to maintain the powers, unity, and also the honesty of the India. Integrity means honesty. Fourth one, to defend the country and render national service when called upon to do so. Number 5, to promote harmony and the spirit of common brotherhood among all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women. It means, children, we have to promote, we have to support, encourage the harmony and spirit of common brotherhood, equality between all the people of India, that also transcending religious means which where we are going beyond the limits, and linguistic means verbal, expressive, and regional or sectional diversities, regional or sectional diversities. And also to renounce practices means we have to reject some practices, we have to reject some incidents which are like making down negative comments on the dignity of the woman, or like insulting the woman, such sort of things we have to reject. Sixth one is to value and preserve the rich heritage of our composition culture. Children, we have to give value, respect, and we have to conserve, we have to preserve our heritage. The rich heritage of or composite culture means, children, it is like a traditional our practices, our Indian traditional practices, Indian culture. We India have a fusion of different cultures and traditions, right? We have to give respect to all the different cultures and traditions in the India, and also we have to preserve them. Seventh one, to protect and to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. And this point is also that we have to protect and also improve our natural environment, like we must not hurt animals and plants, and also water bodies like lakes, rivers, and wildlife. We have to get empathy, we must have a feeling for our mother nature also. Mother nature in the sense forests, water bodies, animals, living creatures. Next, to develop scientific temper, humanism, and the spirit of inquiry and reform. And here, to develop scientific temper means, scientific temper means it is the way that our life, we are using like scientific methods. Scientific temper means how the way of our lives were developed using scientific methods. They are asking to improve more, develop more using these scientific methods. And humanism. Humanism means a person like with non-religious views, and the spirit of inquiry and informants we must get the spirit of questioning, whether it is a good or bad. We must have the right, and we have to develop that way of questioning also. To safeguard public property and to abjure violence, and we have to safeguard the public property, and also we have to stop the violence, to strive towards excellence in all spheres of individual and collective activities, so that the nation constantly rises to higher level of endeavor and achievement. Endeavors means struggles, their attempts to reach the higher levels and achievements. To provide opportunities for education to his child or ward between the age of 6 and 14 years, the 86th Constitutional Amendment Act 2002 has also introduced the 11th fundamental duty under 51 AK, under which all citizens of India or parents shall provide opportunities for education to their children between age of 6 and 14 years. Okay, these are the list of fundamental duties of our India. Now let us discuss about the center-state relations. The Union of India being federal in structure. The Union of India being federal in structure divides all powers between central and states. The center-state relations can be studied under three heads. Those are legislative relations, and next one we can see, children, wait. Yes, administrative relations and financial relations. So, first let us talk about legislative relations. Before starting this, children, before starting this, first let me describe, explain you what is legislative. Here, children, legislate. Legislate means it is a order. It is an order. Legislate is the meaning of legislative or order or rule. Legislative means belonging to the branch of the government. The people who are belonging to the branch of government, who are working in the branch of government, are called legislatives. Legislature. Legislature means like it is a deliberative assembly with the authority to make laws for the political entity, like such as who are living in the city and country. So these are the difference between the legislative and legislature. Why I am teaching before itself is, while teaching this, we will going to come across many words like legislative, legislature, legislate. So you must not get any confusion. Okay. Now once again, legislate means order or rules. Legislative means people who are working in the branch of governments are called legislatives, and legislature means it is a deliberative assembly with the authority to make to make laws for the political entity like in the state or country or city. Okay. Now, the Union Parliament has the power to legislate for the whole or any part of the territory of India, which includes not only states but also the Union territories or any other area for the time being, including in the territory of India. So, this Union Parliament has the power to legislate, to rule the whole or any part of the places in India. So that also include not only the state but also they include the union territories or any other area for time being, for at that moment, and included in the territory of the India. It means even though it is in the union territories or the other area which is outside the India or something else which is included in the territory of India, the Union Parliament has the power to rule over that. Okay. The 7th schedule of the Constitution embodies three lists, namely, the 7th schedule of the Constitution has what? Three lists, namely, the Union list, state list and the concurrent list. Three things: state list, union list and concurrent. Concurrent list means which is parallel, okay, of 97, 66 and 47 items respectively. These three lists are having how many items? 96, 66 and 47 items. So the Parliament enjoys the exclusive power of legislate on subjects enumerated in the Union list. The state legislature has exclusive right to legislate on the state list. So this Parliament enjoys their powers to rule over on subjects in the which is related to the Union list, and that state legislature, the people as of assembly, they have a special rights to rule on the states list. There are three lists: union list, state list, right? They have the rule. The Parliament has rights to work on the union list. The state legislature has the work on the has a right to work on the legislate on the state list, and both Parliament and state legislatures have power to work on subjects contained in the concurrent list. Now listen, there are three lists: union list, state list and concurrent list. The Parliament, they legislate on the union list only. The state legislatures work on the state list only, but both parliament and the state legislatures legislate on the contents which are in the concurrent list. But in case of conflict between the law of state and the union on a subject in the concurrent list, the law of parliament prevails. Prevails means wins. So, if there is any conversation or any debate or any agreement and disagreement between these both state and the union, when they have some any competition according to their views in the concurrent list, the law of parliament only wins here and not the state legislatures. Okay. Now coming to the administrative relations. The administrative power of state extends only to its own territory and with respect to which it has legislative competence, whereas the union has exclusive executive power over the matters with respect to which parliament has exclusive power to make laws and the exercises of its powers conferred by any treaty or agreement. So here children, what is meant by legislative competence? Here legislative competence means the legislatures can only make laws within the legislative competence. These legislatures, the people who belong to the assembly, they can make laws within the legislative competence. So, according to this administrative relations, the administrative power of the state, this will extend only within the territory to its own territory, and also it has some legislative competence, whereas the union people, right, the union has exclusive, they have special executive powers, and over what they are having is the matters, the content, the things with respect to which parliament has exclusive power to make laws and the exercise of its power conferred to any treaty or agreement. These union people have executive powers to work on it. Okay. Next one is financial relations. Article 268 to 293 in part 12 deal with the financial relations between center and the states. The center and the states are empowered by the constitution to impose various kinds of taxes, and certain taxes are imposed and collected by the center and divided between center and state based on the recommendations of the finance commissions appointed by the president under article 280 of the constitution. So in article, if you look into the part 12 which is dealing with the financial relations, we have part 12 in that constitution which is dealing only with the financial relations. There are articles from 268 to 293 which lies between the center and the states. Okay, and the center and states are empowered by the constitution to impose various kinds. Both are included in that to implement many kinds of taxes, and certain taxes are imposed and collected by the center and divided between center and state based on the recommendation of the finance commission amendment. Some were collected by the central government and they will divide this between the taxes between the central and the state governments also. Okay, based on the recommendation of whom? Finance commission appointed by the president under article 280. So under article 280, a person will be elected as a president of finance commission, and that person will be giving some list according to the taxes collected by both center and state, and how much they have to divide and how much they have to share to every state. That will be decided and given by the president of finance commission. Okay. Now, late Prime Minister Indira Gandhi appointed the Sarkaria Commission in 1983 to make an inquiry into the center-state relations. So, our Prime Minister Indira Gandhi, late Prime Minister Indira Gandhi ma'am, She appointed Sarkaria Commission in the year 1983 to just inquire the status and inquire what are the relations between both financial and political into the center-state relations. Okay, and the central government has implemented 180 recommendations of the commission. Central government recommended out of 247, 180 recommendations were implemented. It means came into the action. The most important is the establishment of the Interstate Council in 1990. It means the important thing, very important thing is the establishment of interstate. It means within the state council in the year 1990. Now, let us discuss about the official language. Let us discuss about the official language. In part 17, of the drafted constitution that deals with the official language. So just now we have discussed about the financial things, right? Now this one is just talking about the official languages, and the articles which are in part 17 are 344 to 43 to 351. So in those articles what they have mentioned are the provisions are divided into 4 heads. The provisions are divided into 4 heads, and what are they means language of the union, regional languages, language of the judiciary, and text of laws and special directives. So these are the 4 heads which were added in the like the constitution part 17 official language. What are the 4 heads means language of the union. First one is language of the union. Second one is regional languages. Third one is language of the judiciary, and the fourth one is text of laws and special directives. Now children, here the first language committee was appointed in 1955. So the government started acting on the languages also, because we India has a number of languages, right? So there should be some committee which is also having rules and regulations, and which will be having a structural figure of the languages of India. So the first language committee was also started, that was started over in 1955. It submitted its report in 56. So within 1 year this first language committee started and also submitted their report within 1 year in 1956. As a follow-up of the report, Parliament enacted the Official Language Act 1963. So when they are giving the report, according to that report, by seeing the majority of the report, this Parliament started and gave the Official Language Act in the 1963. The act laid down that even after 15 years, English may continue to be used along with Hindi for all official purposes of the Union, and also for transaction of business in Parliament. Now children, here is the thing where according to the majority and according to the report given, the Parliament took the decision. Even after the act laid, even though we got an act laid and we got the national language also as Hindi in the 1963, but after 15 years of that act also, they declare that English can also be continued along with the Hindi. Even though Hindi is there, English should also be continued in our country for all the official purposes, like transactions of business in the Parliament. Again, through the Official Languages Amendment Act 1967, it was provided that the use of English would continue indefinitely. So later, with all these confusions, English was also added along with the national language in all over the country. So this is about the official language. So the next one is emergency provisions. The central government has been vested with extraordinary powers to deal with conditions of emergency. Three types of emergencies are envisaged in the constitution. So the central government has been vested with extraordinary powers to deal with the conditions of emergency. Children, there are three types. There are three types of emergency which are envisaged in the constitutions. The first one is national emergency. National emergency is in the article 352. The president under article 352 can declare emergency if he is satisfied that India's security is threatened due to war, eternal aggression or armed rebellion, or if there is any imminent danger or threat. So children, here external aggregation, it means external aggregation involves like the financial data like bank accounts, credit card accounts, business accounts, investments, all this comes under this external aggregation. So armed rebellion means the people who are fighting against the government with weapons, okay. And here the president has, under the article 352, the president has rights. He can declare any sort of changes, he can declare any statements if he is satisfied with India's security, if there are any threatening because of the war or any financial status data, and also any like terrorist, armed rebel means like terrorist, okay. If we feel it is, if India's security is going to be affected with these things, or if there is any danger, imminent danger means if the danger is on the way to threaten India, at that time the President of India has rights to declare his statement to save our India. When a national emergency is declared on the ground of war or external aggregation, it is known as external emergency. So, if the national emergency is declared, announced on the war ground or external aggregation place, it is known as external emergency because it is just outside, right. On the other hand, when it is declared on the ground of armed rebellion, it is known as internal emergency. So if if there is a threat with the people who are threatening our India with armed forces, it is called as internal emergency. So this type of emergency has been declared 3 times so far in 1962, 1971 and 1973. So this type of this internal emergency, what happened? It has been declared 3 times. That the years are 1962, 71 and 75. Next, state emergency. Under Article 356, the President can declare an emergency in the state if the Governor reports that a situation has arisen under which the government of state cannot be carried on in accordance with the provisions of the Constitution. The continuance of such an emergency beyond 1 year is possible only if emergency under Article 352 are in operation, or the election commission certifies that there are difficulties in holding assembly elections. Maximum duration of the emergency can be 3 years. In this kind of emergency, the states lose much of their autonomy in legislative and executive matters. After such an announcement, state legislature is suspended and the state is governed by the governor or on behalf of the president. For the first time, the president's rule was imposed in Punjab in 1951. So children, this State Emergency Act under Article 356, the president can announce, the president can declare, the president can decide an emergency in a state if the government reports that situation as under which the government of state cannot be carried according to the provisions of the constitution. He can take any decision when he is seeing some problems are arising, when the government of the state governments cannot go along with the supply. Like for example, children, are Tamil Nadu now facing a very dreadful situation, right? Tamil Nadu, Pondicherry, all are because of this COVID. So when you are having any provision problem like finance or some groceries or some transport system, at the time the president can declare an emergency, he can state, he can decide and declare, give an announcement to help the state governments. And the continuance of such emergency beyond 1 year is possible only if emergency under act. And maximum duration of the emergency can be 3 years. This can be in the 1 year, and the minimum is 1 year and the maximum is of 3 years. In this kind of emergency, what happens is the states lose much of their autonomy in legislative and executive matters. Okay. And for the first time, what happened? The president's rule was imposed in Punjab in 1951. Third one is financial emergency, Article 360. Article 360 authorizes the president to declare financial emergency if he is satisfied that the financial stability or credit of the India or of any of its parts is in danger. In this type of emergency, salaries and allowances of any class of persons serving state or union, including judges of the Supreme Court and High Court, can be reduced by an order of the president. This type of emergency has not been declared in India so far. Such that the third one is financial emergency. According to the Article 360, the president has the right to declare the financial emergency. If he is feeling that India is so far safe and no financial crisis arises, he can go on with that. But if he feels that like present situation, if the India is facing some financial instability, what happened is at that time the president can reduce, he has rights to reduce or increase the salaries of the persons who are working in the state and central governments. Okay, even though courts are declaring the rights and regulations, laws, rules of government, the president has right to even reduce the salary of Supreme Court and High Court judges also. And this type of emergency till now it has not been declared in India till today. Okay. Now amendment of constitution. Amendment of constitution. So the term amendment denotes change. Amendment means what? Change, improvement and modification. So in the changes or improvement or modification in the constitution. Amendment of constitution means what? The changes or improvement or modification of the constitution. Usually this term is associated with one or more changes made in the constitution of the country. Regularly these terms will be changed, one or more changes in the constitution according to the, when it comes to the safety and security of the Indian government or Indian people, right? Article 368 of the constitution in part 20 deals with the powers of parliament to amend the constitution of its procedure. So this constitution was drafted some long ago, right? According to the technical development and according to the development of our India and the Indian culture and Indian people, there may be some changes, there may be a need for some changes, right? So if there is a need at that time, according to Article 368 of part 20, there are some rules which deals with the powers of parliament. The powers of parliament has the rights to just change a minor change, minor changes of constitution and its procedure, that too along with the discussion of the panel members. Okay. Now, procedure of amendment. An amendment of this constitution may be initiated only by the introduction of a bill for the purpose in either house of parliament, and when the bill is passed in each house by a majority of the total membership of that house and by a majority of not less than 2/3 of the members of that house present and voting, it shall be presented to the president, who shall give his assent to the bill, and thereupon the constitution shall stand amended in accordance with the terms of the bill. The constitution amendment can be brought about only by the parliament. State legislatures cannot initiate for any amendment to the constitution. Now children, I will be reading this paragraph again very slowly, just understand, okay. This change and amendment of this constitution may be initiated only by the introduction of a bill for the purpose in either house of a parliament, and when the bill is passed in each house by a majority of the total membership of that house, and also by the majority of not less than 2/3 of the members of that house who are presenting for the voting, and it shall be presented to the president, who shall give his promise, who shall give his sign assent to the bill, and thereupon the constitution shall stand changes in according with the terms of the bill. And here the constitution changes, the constitution amendment can be brought about only by the parliament, not the state legislatures. The state legislatures cannot initiate for any changes in the constitution. Only the parliament members only have the rights to bring out the changes in the constitution, and state legislatures are not having any rights to bring any changes in the any of the constitutions, right? Types of amendments. Now listen children, let me read the types of amendments, just underline it, okay. This is also an important thing. Article 368 provides for 3 ways of amendment. This paragraph is not there in your textbook, I think so children. So you can read this in the PPT itself. Only these 3 points were given in the textbook, that is in page number 245. Article 368 provides for 3 ways of amendments, that is by a special majority of parliament and also through the ratification of half of the states by a simple majority. Okay children, wait, something has changed. Yes, but some other articles provide for the amendment of certain provisions of the constitution by a simple majority of parliament, that is a majority of the members of each house present and voting, similarly to the ordinary legislative process. Notably, these amendments are not deemed to the amendments of the constitution of the purpose of article 368. Children, it's not at all very difficult to read. Whenever you are reading, just keep constitution. Constitution means those are rules and regulations, laws of India, LAWS laws, okay. And amendments means changes. If you know the correct meaning for these words while reading itself, you can understand the content. And this constitution can be changed in 3 ways. The changes were in 3 ways. Let me look for it. Amendment by simple majority of the parliament. So changes can be bring out by simple majority of the parliament, and amendment by special majority of the parliament. Third one is amendment by special majority of the parliament and the ratification of half of the state legislatives also. Some main characters can be taken while discussing the changes of the constitutions. Okay. Now the last topic, constitutional reform commissions. The National Commission to review the working of the constitution was set up by our solution of the government of India in 2000, headed by M.N. Venkatachalaya. So this national commission to review the working of the constitution, these commissions were to check over the working of the constitution, was set up by whom? By the government, like government of India in 2000, which is headed by M.N. Venkatachalaya. In April 2007, a 3-member commission headed by the former Chief Justice in India, M.M. Panchi, was set up by then the government of, one second children, wait, let me check. Yes, I thought I have done some mistake, but nothing is there. Yes. In April 2007, a 3-member commission headed by the former Chief Minister of India, Chief Justice of India, M.M. Panchi, was set up by then government to take a fresh look at relative roles and responsibilities of various levels of government and their interrelations. So what happened is in April 2007 there was a commission which was headed by 3 members. So that 3 members commission was headed in April. Member a 3-member commission was started in April 2007. A commission with 3 members had started, and this was led by the former Chief Justice of India, that he is like M.M. Panchi. And also then the government also has to take a fresh look at relative roles and responsibilities. Not only they have to get addicted to like attached to the thing, the government often should take a fresh look ever often at the relative things and responsibilities of various levels of government and their interrelations. So they have to check in the inter and intra also. They have to go through over the rules and regulations and responsibilities which the other governments are taking in the other thing, and also which is happening between the states and central also, and interrelations, that also the government has to check over very often. So these are about constitutional reform, constitution, children. So with this we have completed chapter 1 in civics. So for some books it may not be like a chapter 1, the chapter number may change. So this is the end of the lesson, unit 1, that is Constitution of India. So children, if you have any doubts you can call me and ask me, or whoever the teacher is available there, you can ask them and clarify your doubts. And be prepared, once you have finished going through the video or this recording session, just go through the textbook also. And while playing after finishing the recording, you just read the lesson once. If you have any doubt in particular area or any topic, again you just play this video again and you try to listen there. Still, if you're not able to understand, you can call us at any time. Feel free to clarify your doubts. Be serious in your studies. Be safe at home, and also concentrate on your daily test. Okay, thank you children. So let me sign off. This is Priya from Alpha Group of Institutions. Thank you, ma'am. Bye.